Ms.
Just for
McCarthy?
clarity, do we have to vote on that? Rule 7?
It should be something that's voted on, since it would be, if it, the rule says if a person so engaged in presentation shall be out of order, he or she will not be permitted to speak at the same meeting except upon special leave of the commission. It's a commission decision, it should be voted on by the commission.
Okay,
So do we have to vote that we're going to, we just do it, or we vote that we're going to give her leave? I don't know.
If you
which way.
vote, if there is a motion to give her leave, that would be what is voted.
Otherwise, Rule 7 stands.
Otherwise, she's been found out of order, she's not permitted to speak, absolutely.
Thank you.
all right. Then, is there
I,
a
I believe, Mayor, you have determined her out of order. is
Yeah,
that
I
correct?
have, on 2 occasions. So unless those rulings are going to be appealed, in order for this resident to continue to speak, we need to give special leave. Is there a motion in support for providing special leave to this resident?
So moved.
All right, we have a motion to provide special leave. Is there support?
Support.
All right.
Did.
We'll go with Mr. Brady's motion and support by Ms. Glissman. And we will take roll call.
Commissioner Brady,
Yes.
Commissioner Glissman,
Yes.
Commissioner McCarthy,
Yes.
Commissioner Petrie,
Sure.
Commissioner Atwood.
Yes.
Motion carries. All right. Please state your name and residence for the record.
My name is Maxine Henderson. My residence is Lapeer, the city of. May I continue?
You may.
Okay, so I just want you guys to imagine this. Imagine trying to silence a eloquent, well-mannered, highly intelligent woman for reading the definition of a word. Now imagine that you're surprised when the village loudmouth comes in and starts to mess with you. Now imagine making up lies and dragging a man's name through the mud, trying to have his professional license revoked, something I can only assume he actually worked for. Like, quite literally trying to ruin his livelihood. And then imagine being like, making attacks on our personalities is really mean. Really mean. You guys shouldn't do that. Like, you'd have to be like a total idiot to think that way. Anyway, so I'm very privileged to be able to come here and tell you all off to your faces every week. But after many messages, I've realized a lot of people don't have that privilege because they're working and they have things going on. So I've got a few here that I'd like to read. I'll start easy. Anonymous wrote, Stephen Brady, you suck. But thank you for standing up for all of us. You're really annoying. Pissant P says, Mayor Hing, before you took the chair, you swore an oath to support the Constitution. On May 18th, you ruled Ken Kopnick out of order and told him he could leave. On June 1st, you ruled Kelly Nolan out of order over a word. On August 10th, you sat in that chair and you read that same word out loud yourself. No policy, this commission writes, sits above the First Amendment. What a resident says in their 3 minutes is not yours to approve. Will you apologize to Ken Kopnick and Kelly Nolan out loud from the chair tonight? Terry A. writes, I can't walk easily. I rely on help from friends and family a lot of the time. I never thought of how difficult it could be to go there and make a comment until now. I've never had anything to say until now. I didn't realize I have a right to be heard and that right could be ignored just because I can't fight back. How do we protect ourselves? Even if I could come there and speak, I would be afraid to come there and say something, especially because we're forced to identify ourselves. I live alone. Sometimes you don't see the faults in your system until someone comes along and exploits them. Thank you.
Thank you. Any others? Straight back.
Leslie Getz, resident of Mayfield Township, candidate for state representative. I understand that the commission will not answer my questions, so I'm asking it as a, think about this. I've read carefully the language of the suggested motion here, and I see that you are going to consider dismissal, suspension, disciplining of, and or to hear complaints or charges brought against the city manager and to afford him the opportunity to respond to the same. My question is the city manager afforded the opportunity to have people, witnesses, people that have interacted with him, not comment about complaints, but comment about positive experiences, because that seems a fair way to approach this. I do not necessarily condone the previous speaker's actions. However, I also wish to point out to the commission that there have been many speakers that I have observed who have not given their name.
Thank you. Any others? Right here.
I would like to make it known, my full name is not Gigi. My full name is Bridget, and I have never had an issue when I've given my name. Do I need to, just for my own clarification and edification, always give my legal name, Bridget?
I'm sorry, Gigi, we don't do question and answers during public speaking.
I
You
have a
can-
comment, and I want to know before I give my comment, if I have to give my full legal name, or can I give the name Gigi?
You heard the deliberation that we just had.
And I
You've
was
consistently-
unclear.
You've consistently given Gigi. I do believe on one occasion you clarified that your legal name isn't Gigi, and you did provide Bridget at least once that I can recall in the
Okay,
past.
I just want to make sure that I'm
You're-
following the rules.
You're known here,
Okay,
and you heard the deliberation,
Okay.
so
I was just a little unclear with the
You're-
deliberation.
you're eating up your 3 minutes.
Sorry, I'll try to be fast then. I just wanted to say that I had been in touch with several disability rights advocates, as was requested by Mr. Francis. And it sounds like from what I've spoken to today, I was just speaking to one while I was in the hallway. You cannot have a blanket statement of what you will do for every disabled person as a reasonable request. Each reasonable request must be for each individual to meet their this disability and their individual circumstance. So when building a policy for disabled persons who cannot make it to this meeting and would like to have public comment, you need to meet on an individual basis. Just so I'd let you guys know, I'm learning more and I'm getting more resources, and I will have an email for you guys soon. I've just been dealing with Lapeer Days and volunteering. So I've been a little bit behind, but that's what I've learned so far, and I'll get more for you soon when I can. Thank you.
Thank you. Thank you.
Thank you. Any others? Blue hat.
Sorry.
Okay.
Hi, my name's Gerald, Lapeer resident. Most of you know me as G. And if you don't, I'm G. It's because I'm gangster. Anyways, thank you, Mayor and members of the commission. Tonight, I'm here to talk about Mike. You don't have to agree with every decision someone makes to recognize that they're doing good work. And I believe Mike has done a good work for Lapeer. During his time as city manager, he has kept the city moving forward. Projects continues, staff had support, problems were addressed, and City Hall had leadership that they could count on. Being a city manager is not about making everyone happy. Sometimes you have to make difficult decisions. Sometimes you have to tell people something they don't want to hear. And sometimes doing your job can make you unpopular. But being unpopular is not the same thing as doing a bad job. And this is why I'm disappointed to see things end this way, because I believe Mike deserves better. And I believe the people of Lapeer deserve to ask a few questions about how we got here. This situation did not appear overnight. For months, we have watched conflict grow. We have watched special meetings, outside attorneys, legal bills, and a lot of time and energy spent fighting. And that disorder has cost beyond the legal bills. Businesses and developers look for stability. They want to know that a city has a clear direction and that its leadership can work together. When they see months of public conflict and uncertainty, some of them start looking somewhere else. And that should concern every one of us. We should be trying to make Lapeer a place where businesses want and invest their time and money. Not a place where they look at what is happening and decide to take the opportunities outside the city. So I have to ask, was this truly a decision that the mayor and the voting majority came to on their own? Or was there other voices helping guide them towards this outcome? I'm not saying citizens shouldn't have a voice. They absolutely should. People should speak up. They should share their opinions. And they should hold their elected officials accountable. But elected officials also have a responsibility to think for themselves. The people of Lapeer, to the people sitting on the dais, and we're elected by the people of Lapeer. The responsibility of those decisions belong to them, not the former officials, not political allies, and not anyone else who may have influence but will never be here to stand before the voters. Tonight, Mike might lose his position, but the question about how we got here should not disappear with him. And my message to the people in the room and watching tonight is simple. Pay attention, stay involved, ask questions. Do not focus on what is happening during the meetings, pay attention to what is happening between them too. Because the future of Lapeer should be shared by the people who live here, the people who raise their families here, and the people who will still be here
Thank
after
you.
the politics drama is over. Thank you.
Any others? Straight back.
Karen Miller, Lapeer City resident. I don't know any of you members on the board here, and I do not know Mr. Womack. I only know each of you from watching these meetings. I want to share with you what I and other people feel about these meetings. People from Lapeer, other cities, states, and even other countries unanimously agree that only 2 people on this board behave with decorum, professionalism, and integrity. There is a person on this board who does not display these qualities. This person manipulates others, weaponizes and manipulates language in an attempt to silence anyone who disagrees with him. This person appears to thirst for power and control, and is frequently observed casting aspersions on the good character of board members and citizens in order to silence them. When any board member gaslights, intimidates, bullies, or insults another person, I appeal to commissioners and citizens alike to immediately call point of order every time this person uses any of these harmful tactics. There are only 2 people on this board with the backbone to hold a certain person accountable for inappropriate and harmful behavior where other members enable this destructive, divisive rhetoric. Anyone who tries to bend the rules and regulations to feed his inordinate need for power and control over others needs to be reined in. It is a huge red flag when you give too much power and control to someone who has already been observed abusing those granted privileges. As regards Mr. Womack, the overwhelming consensus is that a certain person on this board cited Womack's poor work performance as cause for termination. The performance review was merely a cover for the real agenda, a personal vendetta. The work performance review was the perfect excuse to give his vendetta a sanitized veneer of legitimacy. Taking advantage of and manipulating some, but not all, disgruntled employees to make exaggerated allegations against Mr. Womack was also used to give legitimacy to this person's personal vendetta. Normally, it is standard policy to give an employee 2 or 3 opportunities to correct his mistakes before he is terminated. This option was not entertained nor offered, which further supports the belief that this is a personal vendetta. I posit that this attack on Womack was never about a workplace violation, nor was it about seeking justice for employees who felt unfairly treated. As you go into closed session, please think very carefully about how you proceed. The Bible says, as followers of Christ, that you are to correct a brother in Christ, not stone him to death in the public square for crimes against the King of Lapeer. And as a citizen of Lapeer, I am demanding that Hing repay the city for the misuse of city funds that he used to secure Mr. Graves' services to help him execute his personal vendetta. We didn't start this fire, Hing did. These expenses need to come out of his pocket, not the pockets of the taxpayer.
Thank you. All right, any others? Right here in the red.
Bill Sprague, resident of the city of Lapeer. I wasn't going to come last week, but I almost had to throw on my pants and come when I watched the thing live on TV, because not only did you violate the charter last week, but you've also violated Michigan law. The mayor is not entitled to spend any money unless the commission allocates that specifically. He was allocated $10,000. The commission can't come back after the violation occurs. And as Mr. Brady so eloquently pointed out, and cover his tracks by having a budget adjustment afterwards. He spent $13,500, of which only $10,000 was allocated. Mr. Brady also pointed out that money was promised and committed prior to tranche 2 being allocated, which is also a violation of not only clearly the charter, but possibly a violation of state law, punishable by a misdemeanor, $1,000, and I believe it's 2 years in jail. And therefore, by the commission voting to violate the law, the other 3 commissioners potentially placed themselves in violation of the law also. Since we can't get a fair hearing there, I may be pursuing the matter with the Attorney General. I've got no answers back regarding anything regarding the other time when I was up here asking if the attorney was giving personal legal guidance to the mayor in regards to the discriminatory charges that were filed by the freedom of religion folks. And if that's happening, I'm sorry, if we can't get a fair shake here related to, I guess, the investigation, and that would include everything that was in the Bodman investigation. Because in talking to commissioners, they don't know what the hell was even in the first tranche. And if it was stuff like developing a rating system, hell, you can get that for free online. Google it. There's 1,000 of them you can do. That is not something that you need behind closed doors. So an investigation into if everything was appropriate behind closed doors, you're not going to get it here. So it probably needs to be done by the Attorney General. So thank you. Oh, one more thing, since I got a minute. In 50 years of management experience with various places, if you'd go out and interview the people that I had to get rid of over 50 years too, you'd probably get some bad
Thank you.
ratings.
Thank you.
You want us? Mr. Schwartz.
Good afternoon, Stephen Schwartz, 29867 High Valley Court, Farmington Hills. Several weeks ago when you met, City Commission violated the Open Meetings Act by meeting with their attorneys without voting to go into closed session. It's violated the ruling by Michigan Supreme Court, Booth Newspapers versus University of Michigan. The mayor and 2 commissioners made slanderous remarks against Mr. Womack at that meeting, prior meetings, in his performance review and emails. These defamatory remarks are harmful to his reputation and career, so I would ask for a full retraction of those defamatory remarks. Tonight you have 2 options. The bad option, if you terminate Mr. Womack, he has no other choice in order to protect his reputation and career to sue the city, the mayor, and at least 2 commissioners individually for a breach of his contract, as well as defamation, religious discrimination, violation of the Open Meetings Act and Freedom of Information Act, and violation of Michigan Whistleblowers Protection Act. And if we have to go that route, Mr. Womack will hire an aggressive, obnoxious lawyer, and he will not have fun in depositions. Better option is alternatively, we can resolve this tonight. I'm going to present you a full comprehensive standard release agreement. I can explain, I'm not your attorney, I can explain it to you when I'm not limited to 3 minutes. Certainly Mr. Graves can explain it to you. It is similar in the amount of money that this commission gave to the previous city manager who was at will, unlike Mr. Womack. Prior city manager received a severance of $125,000, a virtually brand new car, which was valued at $43,000 at the time, and health insurance for his daughter for 8 years. We can all make the correct business decision and non-emotional decision tonight and approve this release and settlement agreement. It's been signed by Mr. Womack. Mr. Graves and I talked right before the meeting. There are 4 small corrections. Since pair 11 doesn't come after 12, my autocorrect messed up some of my paragraphs. We'll fix that. The last paragraph, Mr. Graves asked me to add the words without revocation, which we agreed to. In paragraph 11, clarify that if Mr. Womack is subpoenaed, he can participate in a lawsuit brought by somebody else. And likewise, you can participate in a,
Thank you.
so, and there's one other paragraph of boilerplate Mr. Graves and I
Mr.
worked out. So if I can approach Mr. Mayor, I'd like to give you all copies. Thank you.
We'll take those. Thank you.
Mr. Mayor,
Mr. Brady.
it's the will of the commission to give Mr. Schwartz more time.
I do believe that that's what this agenda is about. I don't think that the public comment is where we are going to do that. Any others? Right on the corner here in the black.
Sheila Mellon Lapeer. It appears some people are in over their heads.
Thank you. Any others? All right. Seeing none, we're gonna move to.
Whoa.
Oh,
My hand's been up a half a dozen times. You
all
went
right,
right past
Mr.
me.
Kopnick, I didn't see you back there. I'm sorry. Please.
I'm sorry, I'll take the joke. How could you miss me?
You know what? We're not gonna do this back and forth. And before I recognize you, you have already been ruled out of order in this meeting for speaking while not your turn and not recognized. So per Mr. Brady's citation of the rule, we would have to grant you special leave to be recognized going forward. Is there a motion to grant Mr. Kopnick special leave?
So moved.
Moved by Commissioner Brady,
Support.
support by Commissioner Atwood. We'll take a roll call.
Commissioner Glistman,
Yes.
Commissioner McCarthy,
Yes.
Commissioner Petrie, Commissioner Atwood,
Yes.
Commissioner Brady.
No.
All right, motion carries. Mr. Kopnick, please.
Thank you for the vote of confidence. I'll give my name, but I know it's already in somebody's vindictive notes in their files. Kenneth Kopnick, Oregon Township. The last several meetings, I have been spoken to outside chambers. I have been admonished for my behavior, my language. I've been told I would be prayed for. And I did a little praying of my own. And apparently it worked because I got a vote to stand here today. What I'm going to say is I've watched this crap go. Stop me if you've heard this. How many lawyers does it take to keep this board screwing stuff into the ground? Punchline, none. The mayor can do it all on his lonesome. Now, it's going to cost us a lot of money, and it's going to continue to cost us money because of this. It's now to the point Mr. Hing is trying to intimidate people from coming in. He was seen at Lapeer Days taking pictures of the float, writing notes about who was and wasn't participating and who wasn't and wasn't behind him. We know what's going on. It's happened before and it will happen again. At this point, I am beginning to wonder what's going on. You may think you're Jesus, but let me tell you something. I know different. I know you all want to talk about how dark I am and I don't understand what's going on, but I do. I've done it at the county level, I've done it at my local level, and I got asked to come here to see the stupidity that goes on. And the people that asked me were right. I'm at this point beginning to wonder if somebody has, as a child, not been spanked too much, like Mr. Brady, but maybe took a few blows to the head, or a little oxygen deprivation at some point playing with a laundry bin. I don't know, but things are not right. And the public better understand, they better step in here. I know it's an inconvenience to come to these meetings and sit for 4 hours, sit 17 minutes arguing with a young lady about what her name is or isn't, and then tell us we're the problem because we speak. Folks, you better get in here. You better start watching. You better start holding somebody to account. Because if not, they're going to bury this city. This city is a joke. You're not going to be able to get another city manager to come in here. And the city manager and several of the people on the board have been nothing but polite. They've answered questions, looked me in the eye when they did it, have not been offended that I've asked and looked for information. And at this point, sir, I know you're going to throw me out, but you can kiss my ass.
Thank you. I'll remind the public that this is the one and only public comment segment of this agenda. So if you have something to say, please say it now, right here. Yep.
Thank you. Heidi Helfer, Lapeer. Over the past couple meetings, I found it rather convenient for the mayor and board majority that a number of people have all of a sudden decided to show up and complain about Mr. Womack. This entire case has been questionable, not in the least because commissioners were never informed of what the Bodman Law Firm was hired to do until after the fact. The investigation into Mr. Womack was done in secret and was revealed only at his evaluation. Therefore, he was never afforded the opportunity to refute the accusations, not even during his evaluation, because Mr. Hing would not allow him to defend himself. When he was allowed to give a written rebuttal, it was basically ignored, and the mayor and board majority continued to bulldoze him, disregarding the fact that they were relying on allegations that had not been proven beyond a doubt. In addition, Ms. Petrie said she decided to personally question city employees regarding Mr. Womack. Based on the hearsay of people she sought out to speak with, she decided that he was guilty of quote-unquote very toxic behavior. This sets up a striking contrast with Mr. Hing and issues surrounding his mayorship. Many of us have come into this public forum to voice our concerns about Mr. Hing's wildly irrational and self-aggrandizing behavior, which in turn has led to his inept leadership. Instead of working to address concerns we have brought up repeatedly, those of us trying to support the community are told we are guilty of various offenses such as mischaracterizing Mr. Hing, making hurtful comments, being angry people who are unhappy with ourselves, and among other things, just being mean. And yet, all of the worries we bring up at these meetings are made glaringly apparent at every meeting Mr. Hing has attended since the beginning of his tenure. However, despite continually having on display the evidence that proves our accusations, we are gaslit and dismissed. The point of all of what I'm saying is, why would we trust you, the mayor and board majority, to pass any sort of objective judgment on Mr. Womack when you accept as fact allegations that have yet to be proven while simultaneously disparaging legitimate accusations and factual evidence as the ravings of people who are just mean and angry? This reveals you to be completely lacking in credibility. As the speaker at the last meeting pointed out, you reap what you sow. And Mr. Hing, Ms. McCarthy, Ms. Petrie, and Ms. Glusman, y'all have sown a lot of nastiness. So prepare yourselves, because karma is a bitch.
Thank you. All the way in the back.
Karen Brasheko, Metamora. So it seems that we've been misled on a few things. Like maybe the man who stood here and said that he was fired about something that happened 11 years ago. I've been told by multiple sources, and I've seen the licensing stuff, that his license had lapsed and he never got it fixed, but he was working as an electrician, so that's important. So if you have other facts than that, I'd like to hear them, but I saw them for myself. So I also got a question from a tipster about, was there a relationship with Bodman before Jeremy Hing even took office? I mean, as far as Jeremy Hing having a relationship with them, because at the September Tea Party meeting where he spoke and he basically laid out his vendetta against Womack, he mentioned consulting lawyers and having a plan. So it'd be great to know if there was any. So why are we here? We're here because of the vision of Jeremy Hing. And speaking of credibility, what kind of credibility does Jeremy Hing have? Was he vetted? Who on earth is vetting people in the Republican Party or the Tea Party? Because just the most basic look into Hing's past reveals just so much. And as I ended the last meeting, you know, I brought up the Spanish, I brought up the missionary work, that's really colonizing missionary work. I didn't bring up the fridge, the $2,500 fridge he asked for in August 2015. It's in his newsletter. That's a very expensive fridge, even, you know, especially back then. But why do this to your family? You know, you got a brother who was in prison, now absconded from the law, clearly for strangling a woman, apparently, strangling. But we hear all these things because within such a small town, you will. Now, Jeremy Hing said in 2 places that he graduated from Lapeer East, like me. But then in another place, he just said a local high school. So I looked in the yearbooks. He's only in 1993 as a senior. But multiple people told me about an incident that happened March 1st of 1993. And they also told me he was expelled. I've heard things about violence, about fighting, about harming people. And I wonder if anyone thinks about Mr. Hing, that incident on March 1st, and if you think about what it does to people seeing you do this to our city now and re-traumatizing folks. Because I remember hearing about that incident when I started that fall after it happened. Do you think about the effect that your actions have had on people? Because what people are saying is there is a deeper vendetta. It's not just about Womack, it's about Lapeer. Maybe bad things happened to you in Lapeer. Maybe you weren't treated well, but maybe you were also not deserving. Well, you were not deserving, but you were doing other things to other people, basically. And it's the Seven Mountain Mandate. It's people going to churches and saying you need to take dominion for your Christianity when this is government. This is government and your Christianity doesn't belong here. You've received 2 letters and you gave me a whole bunch more stuff to send to fire today because you already got a letter from them about First Amendment. Probably going to have an ADA lawsuit too. Thank you.
Any others? All the way in the back.
Ann Shank, resident of Lapeer. I just would like to ask citizens a question. If Manager Womack really, I just learned this last week when somebody spoke up. If Manager Womack so cared about the city of Lapeer, why was he employed by us for 3 years and yet never lived in the city? But he purchased a home in Grand Blanc and applied for a job there. How does one compare to the other? If you want to talk about our prior city manager, he actually at least bought a house in the county. It was off of the golf course, so it was in the area. I kind of would like to see how you can compare how much one's committed to the area they're working in to the other.
Thank you. Any others? Right here in front.
Carol Brown, Mayfield Township. I want to thank you, Mayor, for your integrity, listening to all this bull about yourself. I don't believe any of it. And these people that are speaking seem to be able to dish out a bunch of hatred, and you're taking it all and being respectful and not blowing up at them. As I'm not blowing up, but I think that they should look at themselves, listen to themselves. And sure, they have the First Amendment right to speak, but there's also respectability and integrity. And I think you have it, Mayor. Thank you.
Thank you.
Thank you, Kim.
Any others? Right here.
Geraldine Carson, Lapeer Township. I want to say that they talk about things that aren't true and things that need to be proven. Again, about Mr. Hing. I question all those negative, hateful comments to be proven true or not. I think it was all made up. I think it's just hate speech. I've always said that. There's a lot of hatred here. Lapeer doesn't need all this hatred. We were a good community. I've lived here my entire life. And I can't believe that people are making up things. Mayor Hing has done nothing wrong. If anybody's got vendetta against anybody, it's the people that get up here and speak hatred time and time again. He saved us $16 million from a development would have taken from our taxpayers here. And he has researched. We gave Mr. Womack the $3,000 for a moving expense with the thought that, well, if he's coming here for a job, we should bring him here to Lapeer. He chose not to even come to Lapeer County to live. He bought a house. And I question why he bought that house and what connection that might have with the Edwin Development Corporation. I think that should be looked into because I guess he got a pretty good deal on it. And I wonder why. Mayor Hing and commissioners here, I implore you to think your heart, to think your conscience, your morals, and everything. Mr. Womack was not here for Lapeer. He was here for himself. And I implore you to look at that. He did not make good decisions. Many, many construction and developments that he approved went over budget and came back to you, the commission, to put more funds forward. I know that for a fact because I've been to the meetings. And this issue about the money of the attorney, the reason that was because of all the commotion and the, I will say it again, immature.
Thank you. Any others? All right.
Mayor,
Yes.
I have, if I may.
Yep.
I have a public comment to read from Joey Ford, and I apologize to Mr. Ford if I pronounce his son's name wrong. It's Lokai Ford. Just for the record purposes, before I read, Mr. Ford had requested an accommodation, I believe on behalf of his son, to appear virtually today. We allowed him, the mayor allowed him to submit a written comment as a courtesy while we evaluate that request. So he's asked that I read it verbatim. There's been several emails that Mr. Ford sent with this public comment. I do not believe the public comment portion of his emails changed, but I'm merely going to read the most recent one. I have not compared them to see if they changed.
Okay.
Again, public comment, Joey Ford / Lokai Ford. I'm submitting this written comment because the city of Lapeer has, for the moment, left me without the live accommodation that it previously established and implemented for my son, Lokai, and for me as his parent and caregiver. Let me be absolutely clear. My submission of a written comment today is not consent to written comments replacing my ADA accommodation now or in the future. It's not a waiver of any right, claim, or remedy. The city has already gone through an accommodation process with me. City offered me a virtual option. City personnel established and tested two-way remote access with me. I successfully entered the city's remote meeting. I participated through that accommodation. The city subsequently contacted me before additional meetings to determine whether I still needed the accommodation. This is therefore not a new request that suddenly appeared today. Purpose of this accommodation is straightforward. Because of my son's disability-related needs and my responsibilities as his parent and caregiver, I need live two-way remote access so I can hear the meeting in real time and participate in public comment whenever members of the public attending in person are permitted to participate. Sending a written statement is not the same thing. A person physically sitting in the room can listen to what occurs, hear what commissioners and other speakers say, decide what issues warrant a response, and then speak during the applicable the applicable public comment opportunity. A written statement submitted before the meeting cannot do that. If an in-person participant receives multiple opportunities to speak during a meeting, an accommodated participant cannot be simply relegated to one opportunity where everyone else receives more. Giving someone who requires disability-related accommodation a materially lesser form of participation is not equal access. The ADA requires meaningful and effective access, not merely some lesser alternative. What has happened during the last two meetings is especially troubling. At one meeting, my remote accommodation was disrupted when a member of the audience shut the laptop through which I was participating. At the subsequent meeting, the city's arrangement only contemplated accommodating me during the first public comment opportunity, rather than providing me the same access to every public comment opportunity available to people physically present. When the city's established method failed me, another disabled individual attempted to help me participate by putting me on cell phone and speakerphone. I made every reasonable effort available to me to get myself digitally into that room to participate. Mayor Hing nevertheless denied me the opportunity to speak. That was the second time I was prevented from completing the comments I had been trying to give. And now on August 24th, after the city has repeatedly informed me of the accommodation, after the accommodation has already been implemented, and after the problems at the prior meetings, and after I expressly informed city officials again this morning that written comments do not provide equivalent access, I asked again whether I could simply submit a written statement. I was asked again whether I could simply submit a written statement. That progression matters. Federal disability law requires recognize the concept of deliberate indifference. In plain language, deliberate indifference concerns circumstances in which a public entity has knowledge that harm to a federally protected right is substantially likely and nevertheless fails to take appropriate action. Yes, Mayor.
The timer's going off.
I don't know if the commission would ask that I finish reading. I probably have another two minutes left to read. If not, the public comment has been provided to the clerk in written form.
By voice vote, if the commission would like to suspend its rules, well, we should probably take a, would that be a suspension of rules, Mr. Francis, or do you just want to finish the statement?
I just want to finish the statement. That would be the request.
All in favor, say aye. In terms of giving Mr. Francis unanimous consent. Or no? Is consent
fine
enough,
with
Mr. Francis?
consent.
Consent. All in favor?
Aye.
Opposed? Consent carries.
Thank you. Federal disability law recognizes the concept of deliberate indifference. In plain language, deliberate indifference concerns circumstances in which a public entity has actual knowledge that harm to a federally protected right is substantially likely and nevertheless fails to take appropriate action. At this point, the city cannot credibly claim that it lacks notice. There are written accommodation requests. There has been an individualized accommodation process. The city has itself offered virtual participation. The remote connection was created and tested. The accommodation was actually implemented. City personnel subsequently contacted me concerning its continued use. The city was then specifically informed when implementation failed. And the city has again been warned today that replacing live participation with written comments does not provide equivalent access. Excuse me. Every additional decision made with that knowledge creates a record. There is another aspect of today's events that the city should take very seriously. Chief Howe informed me in writing that the city attorney provided Mayor Hing with options regarding my accommodation. Those options were passed to the mayor for him to determine how the city would proceed. That is particularly concerning because the accommodation issue had already been established, technically tested and implemented by the city. I'm not suggesting that a mayor consulting with legal counsel is itself unlawful, nor am I claiming the existence of a conversation alone establishes a conspiracy. However, if communications or other evidence ultimately demonstrate that two or more persons reach an agreement or shared plan to knowingly interfere with, withdraw, or materially diminish an individual's an established disability accommodation for purposes of depriving loci or me of federally protected rights, an overt act was then taken to carry on that and cause a deprivation that may raise a separate issue of civil conspiracy under 42 USC section 1983, where the governing law permits such a claim. There's substantial difference between obtaining legal advice about how to comply with federal disability law and coordinating a plan to deny rights after the city has already placed actual notice on them. If the latter occurred, I intend to investigate. Accordingly, I'm expressly requesting preservation of all communications concerning the decision to alter, restrict, discontinue, revoke, or replace loci accommodation, including communications involving Mayor Hings, city attorney, the acting city manager, the ADA coordinator, or former ADA coordinator, Chief Howe, the clerk's office, commissioners, and any other person involved in determining what access would be provided tonight. That includes emails, text messages, memoranda, notes, Teams, or other electronic messages and communications concerning the decision to substitute written public comment for live participation, subject to whatever privileges or disclosure rules may lawfully apply. The city and its officials are now on notice that these decisions and communications may become evidence in subsequent administrative or judicial proceedings. I'm also deeply disturbed by public discussion of details surrounding my son's disability and accommodation. Loci is a minor. The commission did not need to publicly air details regarding his disability-related circumstances in order to administer an accommodation. I did not consent to unnecessary public discussion of my son's private disability-related information. Whatever additional legal conclusions ultimately may follow from disclosure discussing the details of a minor's disability accommodation publicly was wildly inappropriate, disrespectful, and completely contrary to dignity with which disability accommodation should be handled. The accommodation process should never become a public spectacle, nor is it an opportunity to unilaterally pull away an accommodation that the city has already established, tested, implemented, and demonstrated that it can provide, and then attempt to substitute something less effective without an individualized process and lawful basis for doing so. I also recognize the obvious administrative reality occurring inside the city of Lapeer right now. City manager position has been going through significant the city manager position has been going through significant political and administrative disruption. Responsibilities have shifted. Person handling my accommodation is no longer serving as ADA coordinator. There appears to be confusion over who is responsible for implementing what had already been arranged. Frankly, there would not likely be this sudden shakeup in my established accommodation if the city manager position were not going through political disruption it is currently experiencing. That may explain the city's internal disorder. It does not excuse discrimination. A disabled child's civil rights do not disappear because City Hall is experiencing political turmoil. City staffing problems are not Loci's responsibility. They are not my responsibility, and they cannot become the reason why less access than everyone else. They cannot become the reason we receive less access than everyone else. The commission should also understand that deliberate indifference can mean when an entity has repeatedly been put on notice at the beginning of this process, the city should pause. The city could have plausibly have said that it was learning what loci required and determining how to implement an accommodation. That explanation becomes increasingly difficult after the city has already implemented the accommodation and then receives repeated notice that officials are interfering with or failing to provide it. I intend to preserve and pursue every remedy available under federal laws if this continues. That includes claims that the city, under Title II of the Americans with Disability Act, requires for appropriate declaratory and injunctive relief, and damages were authorized by law. And where the conduct of individual officials independently violates constitutional rights enforceable under 42 USC 1983, I reserve the right to pursue individual capacity claims where federal law permits them, as well as properly supported civil conspiracy theory that the evidence ultimately establishes. This is not a threat made for dramatic effect. It's notice When my rights or my son's rights are violated, you should expect me to fight for those rights to the fullest extent permitted by law. I find the way this has been handled over the last 2 meetings absolutely disgusting, particularly what I have repeatedly been attempting to say is something overwhelmingly positive. I support the Kiwanis Club of Lapeer's inclusive playground. I strongly support the creation of the inclusive playground at Roden Park. From my understanding, the Kiwanis Club has made enormous progress towards the funding project and is getting increasingly close to making it a reality. I encourage residents, businesses, organizations, commissioners, and anyone who believes children with disabilities deserve to be included in their communities to support this project and donate towards its completion if they are able. As the parent of a disabled child, inclusive recreational spaces matter deeply to me, and there is something profoundly ironic about what has happened here. I have now twice been prevented from speaking while attempting to advocate for a playground whose purpose is the inclusion of children like my son. I sincerely hope every commissioner reflects on that. Finally, do not interpret the existence of this written comment as resolving the accommodation issue. Caps, a written comment will not suffice going forward. I expect the city of Lapeer to restore and reliably implement the previously established 2-way accommodation for future meetings. That access must extend through the meeting and provide me the opportunity to participate during each public comment period or other participatory opportunity made available to members of the public attending in person, rather than creating a lesser category of participation simply because my access is being provided as a disability accommodation. I should not have to fight this battle every meeting. My son's established accommodations should not change depending upon who happens to be the city manager, ADA coordinator, or presiding officer every week. After 2 prior incidents, there should not be a third time that I'm prevented from speaking because the city failed to honor an accommodation it already knows how to provide. Respectfully, Joey Ford, parent and caregiver for Lokai Ford. And again, I apologize if I mispronounced his name. No address in this correspondence. I believe there was address in prior correspondence. I want to say it was New Jersey, but it is not included in this. In fairness to Mr. Ford, I was communicating with him via email and I asked for his comment. I did not specifically ask for his address.
All right. All right. We also have one other email, public comment that was emailed in, which is significantly shorter. So we'll proceed with that in just a moment here. All right. This is public comment, Matt Hart. I don't have residents here, same as you, Mr. Francis. Lapeer City Council. While watching the council meeting on Monday, August 10th, I was surprised to find that the council was unaware about the circumstances that led up to my departure from the city. I wanted to reach out to inform you of those circumstances and to hopefully clear up some untrue statements made in Mr. Womack's rebuttal to his administrative leave and possible discipline. I started my employment with the city of Lapeer with the hopes of making a difference. My family has history here in the city as county residents. I was in a building official meeting when it was shared that the city of Lapeer was in need of help. I thought this would possibly be a great opportunity for me to help a city that needed some experience to hopefully better the relationship between the residents, business owners, and the building department. I was looking forward to this challenge and opportunity throughout my time in the city. I built great relationships with all those I served, including residents, business owners, developers, builders, as well as all my fellow directors in the city. Unfortunately, I was not able to have the same experience with Mr. Womack. Please note, I do service other municipalities on my off hours, one of which I have been with for over 21 years. Mr. Womack was aware of this fact when I was hired. However, he consistently accused me of doing other municipal business during Lapeer hours. I can assure you, I have never left the city to do other business without taking my own personal time. He even went so far as to follow me around the city and watch me on cameras in the office to take pictures of me on my phone and working on my computer. I certainly was on my phone throughout the day. All my city business was forwarded to this phone, and he was made aware of this. I'm not sure what he was trying to prove with all these pictures. I find this to be very demeaning, and I felt very harassed and micromanaged. I was especially alarmed when I found he had over 150 pictures of me in my car, in the office and in the field. I have never been treated this way in over 25 years of employment as a building official inspector. I was accused of lying when I did not admit to assumptions he made about me. My integrity was attacked at every corner. I offered an opportunity for him to join me in the field so he could see what I do. He never chose to join me. I have never been disciplined, nor have there been any complaints in my personnel file. I have a copy of my personnel file, and there is not one complaint recorded. I'm aware that he has accused me of lying regarding an incident on a rental inspection. However, when I told him exactly what happened, he accused me of lying once again. On Thursday, May 21st, Mr. Womack called me off the road to meet in the city offices. He brought me back to talk to me. He asked me a couple of questions about where I was that morning. I was in training. He asked about my training class, and I updated him on the time I left and also let him know that I made a stop on my way back. I had added time to my time card for personal time, as this stop was of personal business. He told me I was fired because he doesn't trust me, and I didn't ask for his permission before I started helping out the city of Grand Blanc. I have one paragraph left. Would the commission authorize the same manner they did for Mr. Ford?
So,
All in favor, say aye.
Aye.
Okay. He told me I was, let's see, again, my hours at Grand Blanc are after Lapeer hours on Fridays. He was able to confirm this with the FOIA he sent to the city to confirm my hours there were without simply just asking me. All along, Mr. Womack's concerns and accusations have been unfounded. He would become angry with me when I refused to admit the wrongdoing he was accusing me of. I am well-known, trusted, and respected building official. Again, I have quite literally never been treated so poorly in any of the positions I've held in my career. To consider Mr. Womack's livelihood when determining his severance is frankly an insult when he did not consider my livelihood when he fired me. He also didn't consider the livelihood of others before me. In the end, I would have appreciated the same consideration. I was 240 hours shy of qualified time to be vested in 2 full retirements, in essence 24 days. This was taken from me without any consideration or even a conversation about how to work together. I tried to schedule a meeting with him to open up communication, but he didn't listen to any of my concerns or invitations to join me in the field. I also find it surprising that my position is now posted as part-time. The administrative assistant was given a promotion and a raise. Now, that is one way to cut down the budget in a building department, I suppose. Please feel free to reach out to me with any questions you may have. All right. Any others? All right. Seeing none, we move on to agenda item B1, disciplinary decision, city manager. I'm going to first defer to Mr. Graves or Mr. Francis on the order here. We have a suggested motion to enter closed session. Is that the order that you would prefer? We also have Mr. Schwartz here to present something.
I think it would make sense, Mayor, to have Mr. Schwartz present, and also the suggested motion is actually to consider discipline, suspension, or dismissal, suspension, or disciplining of Mr. Womack, and that would be a motion. That motion can only be made if it's requested by Mr. Womack.
Okay, so we'll start with Mr. Schwartz and then go from there.
Thank you, Mayor Stephen Schwartz again. So in the release agreement, these are pretty standard documents lawyers use. I was the original author of this. You could probably look at thousands of them, and much of this language is very same. On page 1, we try to who the employee is and who the employer is, and try and make it as broad as possible. The whole purpose of this is This is the agreement. These are the obligations of the two parties, and you're done. There's no lawsuits, there's no claims. Everybody takes their bat and ball, goes home and moves on with their lives. So in paragraph 1, I'm on page 1 in the middle. Paragraph 1, cited, given the division of the elected officials, which I think is a factual, he will voluntarily resign effective today. In his contract, he's supposed to give 30 days notice to intent to resign. In number 2, I understand that there's a zillion commas and a lot of words. The whole point of this is he's agreeing that he can't sue you, can't do for anything, any conceivable type of lawsuit or claim, any kind of injury. It goes through today's date. The reason it goes through today's date, there's a federal law. I'm not your lawyer, so I'm going to state the obvious. I'm not your lawyer. I'm trying to do this as objectively as I can. You have 2 lawyers here that are representing you. There's a federal law that if you want an age discrimination claim under federal law waived, it can only go up to the date that the agreement happens. So if there's slander or some other action in the future, that's not barred, so don't slander. So the last 2 sentences in the middle of page 2, right above number 3. So it specifically says that he's giving up his right to sue you for age discrimination under federal law. That sentence is required to be under this statute. And the only thing he could sue you for then is, other than something happens after today, is that you didn't meet the terms of this agreement. In number 3 is intended to be the mirror image. So everybody's moving on. So you're not going to sue him. Somebody makes an allegation that he took $3 out of the petty cash. You're not suing him in your local district court for some misdemeanor or something like that. That you're done. If number 4, I'm trying to make a way that everybody abides by this and just moves on, and nobody gets cute with any terms. So if either side violates any term in this agreement, they have to pay all costs, and if they go to court and one side wins, the winner gets the other side to pay their attorney fees at $600 an hour that are actually incurred in pursuing that lawsuit. So the point of that is to have a really significant risk if either side's going to violate the agreement. So on number 5, on the top of page 3. So you'll pay him within 10 days after a revocation period. So under the same federal law, this is the only law I know this, he has 7 days to revoke this agreement. If you adopt this agreement tonight, he's going to sign it, and that starts the clock running. I don't know of any case where you can waive that revocation period. I don't want to test that. So you would pay him what, this is consistent with the contract, you would pay him for all the wages, accrued time, and vacation he's already earned. And we laid that out at his current hourly rate, minus any tax deductions. There's money in his health savings account that is to pay for future retiree or future bills. You would transfer that to some other account that's allowed under federal law or the IRS regs, one that he picks. And should he get another city manager job, there's a state statute called reciprocal retirement agreement where a public employee can add together his prior time. He worked somewhere else for 7 years in a city, then he worked here 3. All the money that you have in your account for it to pay his future pension, that leaves your account, goes to city C, and all your liabilities for any pension go with it. So city C assumes all the liabilities. So you're done with that. In paragraph 6, I'm giving you a choice. So in the employment agreement, it says his severance pay is to be paid in a lump sum unless the parties agree otherwise. So if you want to pay this out bi-weekly, if that's your normal pay period, then we put in the number of 12 months pay and his 12 months of health insurance, which is in his contract. And he'll get that. He'll also pay his vehicle allowance for $500, which is in his contract, and a cell phone stipend. It says you'll provide him with a cell phone in the contract, so I think that's a reasonable amount for what is, he already has a cell phone, but that would pay the monthly fee. And so this would end September 3rd, assuming you adopt this would end September 30th of next year, because you have to wait for the revocation period. But you have an option. You will save about $13,000 if you pay it in a lump sum. This is the bottom of page 3. If you pay it in a lump sum, and you will get credit because he's been on paid leave for 5 weeks, so he's gotten 5 weeks of pay, and I don't know, but I suspect he's gotten some vehicle allowance, and so in the cell phone he'll get, and you paid him some insurance, so you'll get credit for that. So it reduces all those, not just the monetary payment, but the insurance time you got to cover. So that's all laid out in B. In C, in order to have an enforceable contract, you have to give something of value to make clear, because I think he already has a right to all these things in B. In C, that's the consideration that makes it enforceable. You'll pay his attorney fees up to a cap of $5,000. I don't think you've hit that yet. Yesterday wasn't exactly a relaxing day for me, but it depends how long we're here. D is you'll pay me, I'll send you an invoice, you'll 1099. In 7, anything that he's vested or right, he gets, and you go to the plan documents to decide what his rights are. In number 8, he waives any right to future employment with this city, and he applies, and commission turns him down. City has no liability to turn him down. Number 9 is required under that federal act. You're required to give him 21 days to consider this offer. He's waiving that. So that one is clearly waivable, so that would be gone. He'll sign it tonight. In number 10 and number 11, trying to get everybody to move on. So if you are sued, he will cooperate with you. It's likely you're going to get sued about something, a zoning matter, some building issue, something where you're going to need him to testify. Hopefully that doesn't happen, but I wanted to cover that. So he is contractually obligated to cooperate with you. You'll pay him based on his last hourly rate for time he's working with counsel to defend you, and time looking for documents and going to a deposition. And any out of pocket. If he's got to go to Alaska, you'll pay for the trip to Alaska for a lawsuit. In number 11, I'm trying to get both sides to shut their mouths and move on. You need to move on. He needs to get another job. So he's not gonna help anyone else start a lawsuit against the city. I put in, Mr. Graves and I talked right before the meeting, put in language that if he's subpoenaed, so if he's subpoenaed, employee X sues the city and he's subpoenaed for a deposition, he has to go. I don't have that in there. He and I, Mr. Graves and I have worked that language out. Similarly, if someone else sues you and one of you are being deposed, you're subpoenaed, then we worked out, we would plug in the middle of that paragraph that you can say that you read the Bodman Law Firm report. None of you were witnesses, so you can't testify to first-hand knowledge of what all those allegations were. You have first-hand knowledge that you read the report. The report is the report. If either side violates it, there's a $10,000 liquidated damage, plus the winner gets the other side to pay $600 now in attorney fees. Again, I want enough teeth so everybody abides by this and everybody just moves on. And number 12, I actually wrote this broader. Mr. Graves pointed out that what I wrote isn't enforceable. So we've agreed to change the language. He can't file any charge with any federal agency except the Equal Employment Opportunity Commission. He's allowed to file a charge, but he doesn't get any money damages. But he could file a charge. No one ever does that because they don't get money damages, but we would change the language. Mr. Graves and I have worked that language out. The next paragraph, 11, doesn't come after 12, so it auto-corrected, so we'll fix the paragraphs. In paragraph 13, I think we agreed I didn't put in that if somebody's subpoenaed for these records, then you have to produce that. 13 and 14 are sort of standard language, use Michigan law. And if a court throws out one clause, the rest of the agreement still stands. In 15, Mr. Graves, your question, I agreed at the very last sentence. After this agreement's effective after the revocation period's expired, he asked, and I agreed that if not revoked. So again, if he can sign it tonight, you vote to authorize this, that starts the clock running of 7 days. He doesn't get any payments until after that revocation period. I don't think I've ever seen a situation either representing an employer or employee where somebody's revoked one of these, but it's theoretically possible. That's the agreement. You can read 500 of these and they look awfully similar.
Thank you, Mr. Schwartz.
Thank you.
Mr. Mayor, may I ask
Yes.
Mr. Schwartz a question?
Yes.
Is Mr. Womack requesting deliberations regarding his dismissal be in closed session or no?
If
Or
it's,
pardon me, dismissal, suspension status generally.
if it's for dismissal or suspension, whatever, I think the answer is no.
Not this time.
So the answer is no. I don't think it's not my call. I don't think you can go in to discuss this, so.
Correct. I just wanted to
Yeah.
make sure we
Yeah,
understood.
no, yeah.
Very good.
Um,
McCarthy.
My question would be, is I would like the commission to better understand what each total package that's been presented equals out to. I have some numbers run here, so that when we're deliberating on that, we understand the total financial output that would happen. And so I don't know the answers to those and how to put those numbers in. I have some questions. Would Mr. Womack be willing for us to go into a closed meeting to dialogue on that so that we can get the total numbers for package A and package B?
I will defer to Mr. Francis whether you legally can do that. I don't know.
I mean, if Mr. Womack approves us to do that, that's the intent of the closed meeting. I
Well,
would
the,
think
the
that.
basis of a closed meeting has to be to consider the dismissal, suspension, termination,
all of
yeah.
Okay,
Or to review a written and legal opinion of counsel. I don't believe Mr. Graves has a written legal opinion concerning this, so.
okay.
All right. Any other questions for Mr. Schwartz at this time? No? Thank you,
Thank you.
Mr. Schwartz. All right, Mr. Francis, without the closed session, how would you recommend or guide proceeding from here?
Well, I guess I may defer to Mr. Graves to see if he has any commentary he's free to share with the commission in that open session.
Mr. Graves?
Thank you. I discussed with opposing counsel the agreement. I think with the changes that were made, I'm okay with the agreement. It's a question of whether or not the commission is agreeable to the terms, and I'm here to answer any questions you might have as your counsel.
Ms. McCarthy?
Ask questions. So when I'm looking at section, let me just go back. When I'm looking at item number 5, it says the employer agrees to pay employee within 10 business days after the revocation. I'm gonna skip all that. Accrued sick time and accrued vacation time. One says accrued sick time, I'm sorry, 232.5 of accrued sick time and 296 of accrued vacation. Those are two separate items to be run at 66.52.
Correct.
Wow.
Correct. And I did confirm that those numbers. Now, the vacation numbers are a little bit different. The total is the 296 hours, but it's two of those are, I think 2 hours are personal and some of it is comp time, but this resolves all claims, then it would resolve those pay claims too. The total is correct.
I had previous numbers when Kelly was with us for both healthcare and life insurance. I do not have those in front of me now. I thought I had shared those, my scribbled notes with Mayor Hing, on August whatever. Do you have those, Mr. Hing, that Kelly had given me? I had given you some notes on the breakdown.
Just check.
I don't see them in here, but I know that Kelly was kind of to work with the numbers. Oh, she has them.
But you have them?
Thank you. I was just trying to run the numbers.
Yes.
I have only one question.
Go ahead.
Under his previous contract, it also talked about his, organizations that we would cover that, but I don't see that in here. That it was, to continue to pay for his,
Michigan attorney license.
thank you so much. I appreciate you, I do, I tell you that all the time. And then there was one other organization, it came out to about $1,000. I do not see that included in here, so does that mean it's not included?
It would not be included.
Thank you so much.
The other thing that I'll point out, and maybe Stephen brought this up, but in the second option, which is the smaller amount, but it would be paid lump sum up front, there could be a reduction in the amount you pay for healthcare and continuation coverage if he were to get another job prior to September 30th, 2027, and took the insurance on that job.
And Mr. Graves, there was an email between you and HR
Yes.
that also outlined some additional balances.
Yep, and that's what I was referring to earlier with 2 of the hours for personal time, and then there were some hours, I think it was comp time. I have a printout in my bag. but-
232.50 for accrued sick time and 246 hours of vacation time. 2 hours of personal time and 48 hours of comp time.
Yeah, which adds up to the 296.
Okay.
Yeah.
And then when I'm walking through here, I see something about, I'm finding it in. Item 6D says there's a $5,000 for his representation of Plain Matter. And yet Mr. Schwartz was mentioning, I'm sorry, I have a rented tongue. He was mentioning that he would be sending an invoice. Is that in addition to the 5,000 or is that about the 5,000? I don't know.
Can I answer, Mayor?
Yes, yes.
That's what I was mentioning. It's $5,000, but your auditor's probably gonna want a piece of paper.
Okay,
Why
perfect.
there's
I'm
a
just trying
check.
to figure that out.
And I concur, I forgot to mention that if Mr. Womack gets another job where he gets similar health insurance, then that your obligation to provide health insurance for the balance of 12 months is cut off at that.
Are there any other questions I can answer for the?
I don't know.
Yeah, Mr. Graves, I would like to know if these terms are not agreeable, what other options does the commission have?
Well, I see several options. Number one, sorry. Number one, I guess I don't need those. Number one, the commission could do nothing. They could reinstate Mr. Womack. I do not recommend that option, considering the circumstances and considering the investigation that was done and the conclusions of that investigation. I can happy to go into more detail if you'd like me to, but that's one option. You could return them to work with some appropriate discipline to address the issues. Obviously, you need to protect the other employees. And his role as a city manager part of that is to manage the employees. So I see that as extremely difficult to implement. Number three would be terminate without cause, which basically you're gonna pay him what's in this agreement now, less attorney's fees. You may end up in litigation over that. Just because you terminate him without cause and you pay him out doesn't mean he can't bring a claim. You could terminate him with cause. And then you would not have any of these obligations that are in there. I would pretty much guarantee that you're likely to see litigation that would come out of this. And then we'll see what happens. And then if I'll answer your question in just a second, or you can accept the settlement. Those are the options that I see. 5 options.
Mr. Rudy?
I think you clarified it for me. So like option 3, terminate without cause would be outside of the agreement that we just heard.
Correct.
Option 5 would be to take the agreement we just heard.
Yeah, so option 5,
Which included.
Mr. Womack would be resigning.
Right.
So there would be no termination or action on the part of the commission. The only action would be to accept the agreement if we were to go through that.
And that comes with language to prevent a lawsuit.
Correct. Correct.
And by accepting his resignation, because I ran numbers. I hate to share the numbers, so I'm just gonna go forward. I'm more than glad to send a piece of paper down. You guys can see what I accrued, if you'd like to see it. So you understand A and B.
I would like to hear the numbers.
I would,
It's public, let's just let everybody know. I just think,
okay.
I would like to do it behind closed doors, but.
I would love to do it behind closed doors. I really don't want to, because it's so divisive that some people are like, no, and other people are like, yes, and so I just make one clarity that when I do A and when I do B, if we do take 1, 2, 3, if we do all these other things, there is then additional costs that come in for future court time, attorney's fees, etc. So I'm just qualifying that it continues to extrapolate out into the future. So I'm gonna just read the numbers as I've accrued them. I could be a little off, but I'm gonna break them down. So the first option A says that we would pay him a amount of $138,777.60. His accrued vacation time of 296 days times 66.52 a day is 19. You can just read this right here, write it down, and then you don't. Is $19,749.12. His accrued sick time, I might have this backwards, 232.5 at 66.52. It's $15,512.40. His car is $500 a month times 12 months. That's $6,000. His phone is $50 a month times 12 months. Is that 600?
Yeah.
I might be
Yes.
off a little bit. Sorry about that. So I'm gonna do this. Sorry. I'm gonna have to add $500 to this. I'm sorry. So that's 222. Give me just a second. Okay. Per his healthcare per Kelly, when I talked to her over a month ago, it was 36,000 to complete the year. His life insurance, I don't understand it. She said it was $723. Go figure. And the attorney fee of $5,000. And if I'm running my numbers out, package A comes out to about $222,322.12. If I do the second one, and please just bear with me, because I had it at 60 versus 600 because it takes a village. The second package, which is the total package of payment because he is accruing the paid time off while he was on paid leave, would be $125,433.60. If I add all the other numbers, it comes up to a total package of $208,978.12. I just want to state that the first one, $222,322.12, is paid out over 12 months on a bi-weekly, and that the $208,978.12 would be paid in a one lump sum. And so those are the two price tags. I also want to just make one more statement, and I'm sorry I'm taking so long, but we talked about comparatively when we were talking about the past city attorney. I'm gonna go look for you, Mr. Schwartz, because you ran some numbers for us. And for the life of me, I can't find it. So we had a past city manager leave. He went with 120 plus about a $42,000 car. That's 162. And then healthcare for one daughter until she hits, I think, the age of 26. I can't remember how many years it was. But accrued, not for just 1 year, but for the amount of years, it also could come out. I'm just gonna make an assumption of 36,000. So you have 120, you have 42, you have 36, and you are at, if I add my numbers up, and again, it takes about $188,000 that happened 3.5 years ago, under our previous city manager, Dale Ferguson. I just want to give people a comparative so that they're not freaked out about the numbers that are being put on the table and where this is going. And why I'm discussing it is just, we have to think very carefully when we make this decision against, do we want to continue to move in this direction that accrues us more attorney fees? Or do we want to walk away today where it's maybe not a win-win for everyone, but it's something that everybody can kind of move forward and put a period in the situation? That's I'm just contemplating it, thinking it, I'm just saying it.
Appreciate the comparisons there. I said this in a previous meeting, though I don't recall that the previous city manager had the same context and circumstances being held against him. So the figures are comparative, but the situation is not in any way. Mr. Graves, out of these 5, you'd given 4 of them. If I mean, 2 of them you pretty much are saying are off the table, but out of the 3, which are your best recommendations based on the situation, the context in which we find ourselves in, given all of the information that we have before us?
based on the information in front of you, I think that the two best decisions for you would be to either terminate him with cause or to accept the settlement, make a decision. I mean, it's a business decision that you need to make. You know, we have a defendable case. Could it be a very hard fought case, and could there be liability? There is absolutely, and Mr. Swartz will tell you the same thing. In litigation, there's a risk, anything can happen. So there's one route where you know what the result is going to be, and there's another result which could be win big or lose big.
All right.
I think, I can only speak for myself, maybe other people will nod their head, I've been sick over this. I have not slept, I have not eaten, this is not a super simple situation. Take apart everybody's personal issues in it, and it's a tough situation. It's just tough everywhere around, and nobody's thoughts up here, I believe, are wrong. You know what I mean? Like, everybody has the right to those thoughts. It's just a really tough situation. I just want to say that because I don't know if everybody out there understands it's not so harsh and critical and vendetta. I think we're stuck in a tough situation. Sorry.
All right, Mr. Brady.
Yeah, I think it's worth pointing out there is an intangible or a non-monetary cost to setting the city up for future employment, for getting ourselves in a position where we can move forward with our own goals that we want to move forward with. We've got some litigation costs that we've already incurred. I also am ready to put this to rest, and that would be why I would like to make a motion to accept the settlement as it was presented.
Well, could I just caution you, right? Mr. Swartz pointed out that he and I have agreed to some slight changes to the agreement to fix it, but as discussed.
As discussed.
Point of clarification. Commissioner Brady, would that be option A or option B?
My understanding was to go with option B, the lump sum, but that could receive discussion, I think.
And that brings me up, I think I should probably clarify this. The way that I read the agreement, and Mr. Swartz, tell me if you disagree, I think it's at your, you could approve the agreement and then you decide whether you can take option A or B. I think either way, it's an acceptance on their part.
Correct.
I would like to see if this is the direction we want to go before we try to get into the weeds about that.
I'd like to know,
Support.
Okay, it's a non-discussion. Okay, I'd like to know, Mr. Swartz mentioned that we'd like to move on from this. I would too. What guarantee do we have that social media and leaks that have been done will for sure not be leaked or used through a fake name, fake account to cause defamation or harm to the city, as has already been done? I mean, do we have anything written in there that can't be used? Social media, any of that type of thing, leaking to alternate media places? Do we have any assurance of that, Mr. Schwartz?
Asking you?
So, I struggled with that. That paragraph I struggled with all day yesterday, including taking a 2-hour break to pull weeds in case I thought of something. That's why I put in the $10,000 liquidated damage. That's why I put in the $600 attorney fees, and that's why I put in the sentence that neither party's liable for what a third party will do. So, if you've noticed, some people that come here agree with what you're doing, some people don't agree with what you're doing. You can't control what George Washington or Abraham Lincoln say. assuming those are real people, okay? You can't control that, and he and his wife cannot control it, also binding his wife. So it's one hell of a risk, for either side to play games with that. He has told me, without waiving attorney-client privilege, told me repeatedly, he's not on social media. There are probably people, I'm gonna predict, that some people are gonna agree with you, some people are gonna disagree with you. If there's litigation, it's pretty broad discovery of finding out, having people testify under oath. IT people can, Mr. Mayor knows way better than I, but there's ways, I think, to figure out who's sending what. I'm the only person in America not on Facebook, because I like, but this is the best I could do. And I really struggled with that, okay? But I can't emphasize enough that it's in everybody's interest. Just move on. Go pick your next manager, work on your projects. Seems like a really nice town. I've never been here before. Focus on moving forward. He needs to focus on finding a job, not fighting about this anymore. There are people, you're gonna see social media comments, agreeing with this, not agreeing with this. We can't stop that, but we can stop ourselves. So I can't think of any other. I put in 2 nuclear bombs in here, the $600 an hour attorney fees. Believe me, in a lawsuit that you get really high, really quickly at that figure. And the $10,000 liquidated. I don't know what else to do with this.
Mr.
If it
Schwartz.
was, I would have written it in.
Thank you, Mr. Schwartz. I think this is more than just about social media and Facebook. There is adversarial media outlets. And why this is such a great concern specifically with the members that this agreement would be a part of is because there is a adversarial media outlet that received digital unredacted copies of communications that only 3 members had privileged access to. And the only benefiting member of that type of exposure, the way that it was taken out of context and framed, was Mr. Womack himself. Myself and Mayor Pro Tem were the only other 2 that were part of that communication, and somehow it showed up in digital form, unredacted on adversarial media. There's also an adversarial website against most of this commission that you've heard quite a bit about here. No sooner than you had delivered the rebuttal, the response, Mr. Womack's response, which was about approximately 22 pages, that showed up on that adversarial media webpage instantly. And it was the first instance that the complainant's full name was exposed to the public.
So to respond, I'll say 2 things. All my conversations, again, without waiving attorney-client privilege, he's emphatically stated he's not doing that. Secondly, I put in a specific sentence for you to say and he to say. So it's well, I was in response to Commissioner Petrie's question, I was talking about social media. If the Detroit Free Press or the whatever, and I don't even know the name of the outlet, okay, I mean, I think I heard it last time. They contact me, they contact him. I'm not gonna respond to them. I had a situation, I represented the manager in Farmington Hills a couple months ago. Several major reputable news entities called me, said I'm not gonna comment. I didn't even talk to them off the record. I'm telling you unequivocally, that's what I'm gonna do. He's not gonna talk to them. In the same way, if they call you, you've got a sentence to say, and that's why I put those 2 sentences in there to bind everyone. Again, if somebody thinks that's been violated, there's a hell of a penalty in terms of attorney fees and liquidated damage. You know, there's discovery. I know not everything can get discovered, but again, I don't know how to say it. Everybody needs to move on. Okay, it's a difficult situation. We're all doing the best we can. It's not coming from me. It's not coming. It's not going to come from him. It's not going to come from his wife. His wife's sitting out in the hall. Okay. Again, if there was something else I could do, I would have put it in here. I can't think of it, and I've written a zillion of them, so.
Thank you.
So and I'll just kind of reiterate a little bit what Mr. Swartz is saying. The language is specific. Employee agrees that he and his spouse will neither take nor encourage any action which disparages employer or which in any way reflects negatively on the employer's operations or management. If asked why he resigned, employee shall state only, I resigned because the elected officials were badly divided. Employee also agrees that he and his spouse will not discuss or refer to his employment with employer on social media. There are similar restrictions for the commission for the city. Those are about as strong as you can get in an agreement. You know, I've had situations where people have violated these things and done bad things, but if you put in a lot of effort, you can catch the person. I've used, you know, former FBI agents that will go in and get IP data from people's websites or where they're sending emails from, and you can, you know, where they use fake emails and do all kinds of stuff. You can eventually catch them at great expense. But you know, if somebody's going to be underhanded, they can be underhanded nowadays. And you know, with the electronic world we live in, it's not easy to catch someone. That's just a fact.
I'm so sorry, I'm just gonna keep running these numbers so people understand what the thing is. So, I just Googled here and I do apologize, I wasn't paying attention, but I tried to Google, you know, what could the average hours be on something like this, and nobody knows. But if 100 hours are spent at $600, we're looking at 100 hours to prep for this case. It's another $60,000, and we could potentially, just 60,000. That's not even saying if you go in front of a judge, you never know what they're gonna say. You never know how they're gonna fall. It's trust me, it's give or take any day. And then they could also award attorney's fees from the other side, so then you're looking at double of that. So we're looking at, in addition to these packages that I just said, rather than doing this, we could be looking at $100,000 in attorney's fees and still lose and have to pay these packages. So I'm cautioning everyone to think about it, because I flip-flop 96 ways from this, but I'm looking at this and saying, how does everybody go home at the end of the evening and we move on and we start to heal as a city? And no one's gonna be happy with this decision. There's always gonna be someone in our city, in our community, that thinks that it's the wrong decision, no matter what we pick. I'm just cautioning us that we don't know the unknown, but this is a known that we know. And I even think there will be people on this dais who will probably be mad at me, but I'm just saying, this is a known that we can walk away today, and we don't know the future, because, and my husband's a judge, and he says, you never know what judge you're gonna get, you never know what mood they're gonna be on any given day, and it can go sideways, and that's a concern for me.
All right. Any other discussion? Ms. Petrie,
I moved for a 5-minute recess.
is there support?
Yes.
All in favor? Say aye.
Yes.
Is there discussion on that or no?
Oh.
I'm all for a potty break. I'm just concerned that there's gonna be a lot of discussion happening during the recess.
Okay, we're all adults here. You don't have to be a parent. So is there support? There was.
I said.
All in favor, say aye.
I'll just turn my
Opposed?
recorder on my phone right now and leave it here sitting at the dais.
Recess.
Thank you.
One of my clients said, I want to be here.
Back to order. All right. Any further discussion before we go to vote? All right. We'll take roll call.
Can I have a motion to read that?
Madam Clerk,
Who said it and who seconded it?
if we could reiterate the motion on the table and the mover and supporter.
Moved by Commissioner Brady, supported by Commissioner Atwood, to accept the settlement as discussed.
I think there was a clarification, yeah, as discussed, and it was settlement B, I believe. Is that everybody's
That
recollection?
is the one lump sum?
Yeah.
Correct. That's my recollection as well, Mayor.
That could be, sorry to interrupt. It doesn't have to be included if we want to just decide if this is the route we're going before we discuss that. That might be preferential.
I believe that Mr. Graves, or it was Mr. Schwartz, said it could be either or as long as you accept the.
Okay.
So
I didn't think we had to pick A or B right now. We could just say we accept, and then that would be, I don't know why we wouldn't pick which one, but.
I would seek to clarify my motion did not pick A or B, just to accept the settlement as discussed.
That was your motion, and there was some clarification whether that was A or B. I believe your answer was whichever was the lump sum. So.
Well, Mr.
The
Mayor.
motion is just the way that the clerk read it, and it does not have either of those things identified, so I think you're clear.
Mr. Mayor, if I could just add,
Yes.
there is a, for the commission's knowledge, there's a due date on the lump sum payment that would be 10 days from signing the agreement. So it can be a separate motion, but eventually the commission would have to decide whether it wanted to take option B.
Okay.
Or within 10 days of the revocation period. Thank you, Mr.
So it'd
Graves.
be, depending, it'd be 17 days after you sign.
Do we have to make a second motion tonight of whether it's A or B? I mean, can we just, or can we just put A or B, okay, like,
Timing wise, it would need to be within 17 days. So I'd have to look at the commission's meeting schedule to see if that was something that could be addressed at the next meeting.
in order to resolve this, do we just pick one and then move forward?
I mean, that's the cleanest way.
Pick one.
Yeah.
Call it a day, vote on it.
Mr. Mayor. My preference is more to just see whether we're going to do this or not. I don't want whether it's A or B to weigh in favor on one side or the other.
It could be a motion. If this were approved, it could be another motion tonight after this. I'm not saying we have to wait till the next meeting. It could be two separate motions.
Any further discussion? All right, roll call.
Commissioner Glissman.
Yes.
Commissioner McCarthy.
Yes.
Commissioner Petrie.
No.
Commissioner Atwood.
Yes.
Commissioner Brady.
Yes.
Motion carries. Mr. Brady.
I make a motion to accept option B, the lump sum payment.
Support.
Motion by Commissioner Brady, support by Commissioner Atwood to accept settlement B. Any discussion? Mr. Brady.
I wish our finance director was in the room. So that's my hesitancy is to really jump in on one or the other. Obviously, we were planning on paying this amount. Probably more of the work that needs to be done is paying for the interim and whatever comes next. So I'm okay going ahead with option B. I like the idea of taking those 5 weeks back onto ourselves. It seemed to me like that, at least as far as I understood it, that's what it was. And then being able to be done.
maybe we should leave that open for, Ms. Hannah to, come up with the best solution for the finances of the city. I don't know that we're going to be able to come up with that, whole amount right now. And so I think that that should be perhaps, tabled until, Ms. Hannah can, look at the figures and tell us what she thinks is in the best interest of the city. And, because I voted the way I did does not mean I'm happy.
Support. If that was a motion to table.
We have a motion.
That's not how it works, but that's fine.
That was just discussion.
I know, but when you make a motion to table, it's a sub motion. You can't do that. We could say we don't want to talk about this anymore. We're tabling it.
Who said we would go? Who said we're tabling?
Ms. Bozeman would like to table it.
I don't want to, I want to ask a question.
Go ahead.
Can we, I don't want to table it right yet, because I didn't get to ask my question. So I'm getting testy. Kidding. Can we make some kind of an agreement that we try to get this on the very next regular meeting that Ms. Hannah gives us her A or B based on how the finances have to work in the city? So it gets resolved and it's within the time periods moving forward. It's, you know, rather than let's wait another 3 to 6 weeks to have this answer, I would rather maybe we all agree that maybe Kelly looks at this and gets us to that point that the September meeting that maybe you guys can vote on that. I won't be here, but you all could vote on it.
It's the 24th. Next Monday is the 31st. The first meeting of the month scheduled is the 7th because the
Right.
first is on a Tuesday. So we're
It'd be the 8th.
because of Labor Day.
Correct.
Yes.
So we're now
Yeah.
2 weeks plus a day.
So you're still within the 7th.
We're within it. Okay.
If it were signed today.
If it falls within it, then if Kelly could give us that information, then we could make sure that it's resolved as quickly as possible so the city can move forward. Would you then, would you then withdraw your motion and then he would support your withdrawal so that we're not having to do something on this, or do we just vote it down?
I withdraw my motion.
Go ahead.
I feel the only thing we're gonna be waiting for is the actual number plus or minus 13,000. So I don't understand the hesitancy of, I mean, I get it, but this is a route we chose to take. It's either A or B. It's gonna be 13,000 less or 13,000 more.
But in one instance.
So why not just get it over with?
With A, you're paying it out over time. With B, you're paying it immediately in one lump sum. So that's the, and B is what is being considered. So I think Ms. Glissman's comment was, we don't know if we have that in one lump sum right now. And we should confer with our Director of Finance. Mr. Brady.
I'm okay with, I agree that, $35 million budget is what we sit on. $10 million, $11 million general fund budget. We have the money for this. Ms. Hannah is very adept and will be able to make sure that this happens. We give direction to our staff, and I would agree with Mr. Atwood that we can give this direction and the staff can present it. If there's a problem, she'll bring us a problem. We've got time if there's a problem. But that's internal work. We've decided what we want to do. We know this is a better deal for us. So I'd like to see us, I guess, vote it down if you have a problem with that.
Mr. Brady, thank you.
I'll withdraw my second. It's easier.
All right, very good. So we have withdrawal. Go ahead, Mr. Tree.
We don't direct the staff. That's been discussed over and over. We don't direct the staff. So without Ms. Hannah here, we can't just say, we'll tell her what to do. We don't get to do that.
Mr. Mayor.
Not right now. There's also, I think, for me, it's a little bit bittersweet, Mr. Brady, because you're very eager to pay a lump sum and direct staff to do so. When you're very diligent, or at least persistent, I should say, about not paying our legal fees to a labor issue and questioning every penny, but you're ready to just fork out over $200,000 instantly without conferring with the financial director, but you want to dissect a $10,000 engagement that has lasted months. It shows some very serious inconsistency in your scrutiny of finance.
Thank you for the critique. I will consider it.
The concern that I have is that when you scrutinize the legal fees over something that we have an obligation to address, especially when we get to the allegations in the investigation, part of that scrutiny comes with claiming that we're being frivolous with the taxpayers' money. I wonder how the taxpayers would feel that we're paying $200,000 when we have an investigation that Mr. Graves is on record here today saying that we have cause.
Mr. Mayor, the commission voted.
That it was defensible. I understand they voted, but I'm making an observation about the critiques that have come my way. You could at least handle a little bit of clarification and understanding of the inconsistency that I see here, especially when you pander to the taxpayer and the public on those arguments when you come against the things that were done here that we have an obligation to based on the allegations and claims. That finalized and brought forth a product that on record today, we understand we have for cause and that it's defensible. And the public needs to know that. And that's taxpayer money that was well earned to get that. And we're still going to do this. So,
Mr. Mayor, may I respond?
I wasn't asking a question.
Okay, I would just warn you that you are getting dangerously close to violating the agreement the commission just enacted.
All I've done is make observations. It's all history and it's inside of the public record. Ms. McCarthy.
We have moved past this because both this motion was made and then it was friendly removed, and that removal was then accepted by Mr. Atwood. So the motion now is dead and no longer on the table. Is that right, Ramona? So for all intents and purposes, we've made a decision. Can we agree, maybe just softly, that Kelly Hanna will then somehow advise the city commission at the next regular meeting what she sees as the best financial possibility to move forward? And then if that's the case, this issue was done. But before we adjourn then, because I will not be at the next meeting, I believe that there has to be, and I don't know, I'm not trying to be insensitive, guys, so please don't think so, but I'm gonna be gone for the next 3-4 weeks. I would believe that then we have to take the next step here. That would be a motion to have the staff reach out in some way to start looking for an interim manager, unless you'd like to be on for a long time. And I would suggest that we reach out to the MML and put in a placement I'm going to just say a few things here. If that's the case, we're going to do. There is a list, I think, from the MML, but Saline didn't do that. They put out an ad as well. And I think that vetting someone who's willing to come here and say, hey, pick me, I want to be an interim manager here, means that they got a backbone of steel. So I would like to at least throw that net out there. And it's unfortunate, but I'm just saying, I'm not going to be here, so I want to make sure that we're taking that next step, that we're at least throwing the net out, maybe an ad in MML like Celine did. We also accrue the list that might be there. Apparently there's some kind of list. I didn't see it on the website. And so that shortly, sometime in September, we start getting names back. So if I have to move for that, and I'm not trying to be insensitive, I'm just trying to make sure that we're moving this forward, because Kelly doesn't want it again. And he's kind of shaking his head no. So do we need a motion?
Mr.
Thank you, Mr. Mayor. Kelly has communicated with Ramona. She said it would be, she was watching from home.
Okay. All right. Mr.
What
Atwood.
answers they-
I make a motion to go with option B.
Support?
Support.
All right. Motion made by Commissioner Atwood, support by Commissioner Glissman to go with option B. Discussion. Okay, we'll do a roll call.
Commissioner McCarthy,
Yes.
Commissioner Petrie,
No.
Commissioner Atwood,
Yes.
Commissioner Brady.
Yes.
Commissioner Glissman.
Yes.
Motion carries. With that, we conclude our business unless others, what do you got?
I want to make the motion.
Go ahead. Ms. Sanchez.
Yes.
Mr. Schwartz.
Really quick. So, so we get the clock running. Mr. Graves and I are gonna probably spend 10-15 minutes making the little changes. Your super clerk will print it out. And then, Mr. Womack and the mayor and the clerk can sign it tonight. That starts all the days running. So please don't run out of here, okay? It'll take us about 10-15 minutes.
Thank you, Mr.
Thank you. And thank you for
Ms. Sanchez.
We need an acting,
I'm sorry.
we need an acting city manager. Mr. Howe's term expires today.
Mr. Carthy.
I will continue the process until we get an interim in, but hopefully much sooner than later.
Yeah, we need to take action on that right now.
Thank you, Chief. I move that we, ask Chief Howe to be our, acting city manager until we get an interim.
Second.
Motion made by Commissioner Petrie, second by Commissioner Glissman to continue Mr. Howell as the acting city manager. Any discussion? All right, roll call.
Commissioner Petrie,
Yes.
Commissioner Atwood,
Yes.
Commissioner Brady.
Yes.
Commissioner Glissman,
Yes.
Commissioner McCarthy.
Yes.
Go ahead, Ron.
I move that the city commission approve our staff to start the search for an interim city manager to include advertisement in the MML job search section of their website, so that we can start compiling possible interim city manager resumes for interview.
Second.
All right. Motion made by Commissioner McCarthy, second by Commissioner Petrie to post advertisement for a new interim city manager. Discussion. Mr. Brady.
I would defer to Mr. Atwood.
Mr. Atwood.
Yes, we already have, the MML or the MME provides lists of interim managers. So I appreciate the motion, but I do not like the motion. I like the motion to direct the staff to, or direct, acting city manager Chief Howe, to work internally, with staff to give us some options on what they think is best for the city, moving forward with the interim, rather than hiring, a firm at this time.
Just for clarity, I don't believe that my motion in any way talked about hiring a firm. It said put an ad in the MML job search, which is exactly what Celine did. And then they would enter their things in if they want to. We could include the list, the MME list, but I would like to spread that list a little wider to see who might say, wow, I think that's an opportunity and a challenge that I'd like to take on. I mean, honest, I mean, if someone does that, they gotta have like a backbone of steel. I'd like to see if any, no, maybe nobody does it, but mine didn't say hire a firm. Mine said put an ad in the MML. Celine did it, they didn't just take a list, they have it in there, so that's someone right now active, I just looked it up. I just think it's, you put the ad into paper, throw out the net, get the list of MME, call them too. Some of those are gonna turn it down probably, so I just want us to have, not incur a lot of costs, just put an ad in the paper, so that, that's where I saw Celine's, I don't know where else you would put it.
Any other discussion? Mr. Brady?
With the motion on the floor, is the motion, is there a point person that, like, internally from our staff that's,
I wouldn't know who that would be, it'd probably be our HR director that would probably be the I mean, we're just giving them the freedom to start the process and kind of how we, you know, move forward. But they would have to tell us who that person is, I would not know, I would think it would be the HR would collect them. Maybe that would be the point of contact, I don't know those details. It certainly wouldn't be any, well, maybe it's you,
Well, it would go to HR.
okay.
I mean, it might come to me at one point, but it would all go to them.
Maybe it's
Any further discussion?
So we're looking for an interim city manager?
Yes.
Correct.
Take a roll call.
Commissioner Atwood,
Yes.
Commissioner Brady,
yes?
Commissioner Glissman,
Yes.
Commissioner McCarthy,
Yes.
Commissioner Petrie.
Yes.
Motion carries. Mr. Francis, is there any other business that you?
Not tonight, Mayor.
Okay. Mr. Riggs, Mr. Schwartz, anything from you?
We'll get to work, and if we could just have you, Jeremy, and Pete, for acting city manager.
Very good. Meeting adjourned.
Blow it away.
Thank you.